Okay, good afternoon, everybody, and welcome to today's webinar, episode 6 of Association Continuity in a COVID World. My name is Craig Vaughn. I'm the president of Castle. For those of you who don't know Castle, we specialize in the management of HOAs, condos, and apartments in Florida. We partner with approximately 300 associations through 7 offices and 1,750 teammates. Now, welcome back for those of you who are rejoining us, and welcome to our new webinar participants. For those that are new, I promise this to be a riveting hour, probably the best hour you'll spend on the internet all week. So please sit back and enjoy yourself. As always, we welcome additional questions. You can chat in questions as Marinus described throughout the webinar, and I'll attempt to work those into the discussion. Backed by popular demand is polling. Polling is a feature we introduced a couple of weeks ago. The feedback we received is that you enjoyed hearing what other associations are doing. So we're going to have some updates on that material as well. We also listened to your feedback and simplified a couple of questions so it's easier for you to scroll through the questions when we get there. We encourage you, of course, to quickly answer the questions when they pop up, because we will move to the results fairly quickly. Let's start with our first question before we get to the guys. Question number 1, what type of community do you live in? And is your community a 55 or better community? So it's kind of a 2-part question. I want to welcome back, will you answer that? I want to welcome back Michael and Jeff. Before I ask them to introduce themselves, I want to remind everyone that they are not here to provide specific legal advice for your association. We are just having a discussion, and they're providing an objective opinion on the items that come up today. For questions specific to your association, we would encourage you to reach out to your legal counsel. Jeff, we welcome back, and if you could briefly introduce yourself and the firm.
Thank you, Craig. Jeff Rembaum with the law firm of K. Bender Rembaum. For those of you who have not been on our webinars before or don't know the firm very well, we are 19 lawyers, about 25 staff, devoted to representation of Florida's community associations. We represent a little over 1,200 or so community associations with offices in Palm Beach County, Broward County, and Hillsborough. 9 of our lawyers are board certified experts, and this is really 99.9% of what we do. So if you're ever thinking of new legal counsel, please do consider reaching out to us. If you're happy, then by all means stay with whoever is helping your association now. Also, as Craig said, anything we talk about today, you need to go back and check with your lawyer to make sure they're on the same page with anything you might hear and advice that you might want to put into action. Because of today's webinar, you definitely want to go back to your local counsel and make sure they're on the same page. The firm also puts out 2 publications on a regular basis. Legal Morsels, my partner Robert Kay puts that out periodically, and I publish Rembaum's Association Roundup. Its purpose is to keep everybody informed on new court cases and developments in community association law. Greg?
Great news, Jeff. I did hear 1,200 accounts. I'm pretty sure we're not the management company for all 1,200 of those, but I know that's an issue that we're working on, so I do appreciate that. So, on a regular basis, lead your roundup and really much appreciate the concise nature in which you framing the issue. So thank you for that. Michael, your introduction?
Sure. Hey, everybody. Mike Bender. You know the firm. I hope welcome any new participants and welcome back to our regulars, if you will. And just a couple of things to add to what Jeff said about the firm. In addition, we have office locations in Miami-Dade. Those are by appointment only, so we do meet with clients down there. We do plenty of Zoom meetings now, so we could be pretty much anywhere with regard to that. And we're also very active in legislation. And as a firm, we work with the Florida Bar subcommittee on condominium and plan development law. I actually serve on the Florida Legislative Alliance, which is a legislative arm of Community Associations Institute. So that's just another aspect that we bring to your attention. And then the only other thing I want to remind is today, even in a very limited time, we're talking in generalities. I know some of you might be clients of the firm, and we're happy to be able to speak with you this way. But with regard to your specific instances, regardless of who your counsel is, you do want to follow up with them and get specific guidance as to your situations, and make sure that you're following proper processes and procedures, which we'll get into a little bit more today. But it is a limited amount of time. We are offering information only, and so please don't walk away from here saying, we just got legal advice and this is what we need to do. Please do reach out. This is why you want to use your experienced association counsel to help you run your business. These associations are businesses that you're running, some big, some small, but that's why you have your management team, you have your insurance experts, you have your accountants, and you have your legal team, and you want to reach out to them, and you should budget some of your budget for these expenses so that you can be running your business properly.
Okay, guys, well, thanks a lot. I just wanted to quickly revisit the last month, how quickly things have changed. A month ago, we were having a discussion on whether to open amenities, and then working through the nuances of all the various local orders that were in place. And then we were hearing a month ago, roughly 40% of the participating associations in our webinar who answered the poll had not opened their pools yet, and 55% were allowing non-essential visitors. A number of associations at that time clearly had not opened their pool, and it's still allowed. It's still, a factor. You don't have to open your pool, which is something that we've seen chatted in as a question. But 2 weeks ago, so we moved from a month ago when we were having the discussion to 2 weeks ago, we were talking about, there were no new regulations. We were getting giddy about the opportunity to really start to open things up, maybe even relax the rules with respect to visitors and guests. And then here we are today, the backdrop being a record number of new positive tests daily, new guidelines specifically related to masks, which we'll address later, and then clearly a heightened level of concern over what's going to happen in the next little while. So let's just run through today's topics. We're going to have a current legislative update, as always. With respect to amenities and non-essential visitors, I really just want to check in, and we're going to poll our participants to see what's going on in their communities and whether there's been any change from the last 2 weeks with respect to amenities and non-essential guests. We're going to talk today about rule enforcement, what tools the association has, what they need to make sure is in place to be able to properly enforce the rules. We'll have a question and answer session, and then we'll quickly talk about what's next. Before I get going on the current legislative update, Ness, can you please post the results on who's in the audience today? So about
Craig, in the audience today for the first time, I just want to do a shout out to my parents. They figured out how to Zoom, and they're joining us today.
Hello, Mr. and Mrs. Rembaum.
Hello, Mr. and Mrs. Rembaum. Welcome aboard. That's really funny. So with respect to where do they live, 62% are in co-ops, 38% in HOAs, which is about what we've seen. And then is your association a 55 and better community or 55 plus community? 35% of respondents are saying yes, and 65% aren't. So about the same mix as we've normally got. So guys, let's move on to the current legislative update. We're still under the state of emergency, set to expire Tuesday, I think, July 7th. So 7th. Next week. We were hoping that we'd hear from the governor to address this looming deadline before our webinar today. We didn't, so we'll anxiously await his guidance. Michael, I know that you are active with with legislative matters, given your role as chairperson of the Florida Legislative Alliance. What are your thoughts with respect to the likelihood of an extension?
Thanks, Craig. And I mirror what you said. It's unfortunate, in my opinion, that we haven't received an indication of an extension prior to this weekend. Unnamed sources and unconfirmed reports, if you will, indicate that they're waiting to see how the 4th of July weekend plays out before deciding whether to issue the extension. I have heard that I anticipate, based on everything that we have been, again, just how you opened up today's seminar, what we're all reading and what we're all seeing, I would anticipate there being a 60-day extension. There was some discussion about whether, how you've seen how certain orders have come from the governor, even reopenings that would exclude South Florida. And so there is some discussion about whether the extension of the order would only be in certain areas and not the whole state. But I believe that might have been talked maybe a week or two ago, but because from what I've been reading, and I think we've all been reading, is the numbers in the state are going up everywhere. Whereas South Florida had over 50% of the cases a week or two ago, I believe we now have less than 50%, even though the South Florida numbers have been going up, which just goes to tell you the numbers are going up everywhere. So my firm belief is we'll get an extension, but I don't base that. I base that mostly on optimism of doing the right thing.
Well, we'll go with your gut, and I think we're all in the same boat. As a reminder to our listeners, it was the state of emergency order that triggered the emergency powers in the statutes, 718, 719, 720, that the boards used to shut down, amenities and restrict access. So I think it's in our best interest, all of our best interest, for the order to be extended. So we will sit with bated breath and wait for the governor to tell us what his thoughts are. Jeff,
yeah. But Craig, if I can just also say real quick, because I think this is relevant to the legislative aspect, is these orders that are being issued by the counties and by the municipalities. If for some reason the governor wasn't to extend the state of emergency, I don't believe that automatically extinguishes these other orders. That's something that would have to be further looked into. We're going to get into it later, but the most recent Broward County order that took effect takes effect as of midnight tonight. It says in there, it expires upon the expiration of the existing state of local emergency. So, so there is something, so that's something that people should be aware of. That hopefully the governor will do the right thing, because I think it's a trickle down theory, but there are, there is the efforts of the counties, there's the efforts of municipalities, and as we'll get into more, the efforts of the associations, which is why you're all here, that we'll talk about. That doesn't mean it goes away if the governor doesn't extend it.
Yeah, it's a good point. And Jeff, there is some worry if they don't extend it. Anything that the board needs to do immediately, or do they have some time to react if it's not extended on Tuesday?
Excellent question. If it's not extended, the language in the statutory emergency powers does lend itself for the board to continue to be able to use the emergency powers for a reasonable period of time thereafter. So just because the state emergency order or a local emergency order eviscerates doesn't necessarily mean that the emergency powers used by the boards to protect the building and to protect the occupants will just eviscerate. That will be something that the board is going to have to be in consultation with their lawyer about, and they're going to have to make reasonable business decisions as to the, risk analysis as to whether they want to continue to employ those specific emergency procedures. And as you are aware, and I'm not going to go backwards into our prior seminars, there is still some debate as to whether those emergency powers were relevant to the COVID-19 situation. You'll find most of the practitioners that deal with this on a daily basis, such as Michael and myself, believe absolutely they do. Whereas you'll find those that are behind offices in governmental buildings in Tallahassee, some of them are taking a position that no, they don't. So we'll see where that ferrets out, but we still believe it's up to the boards individually to make that decision for themselves. So while we support it, we can't promise a court of competent jurisdiction at the end of the day would agree. We'd be surprised if they didn't, candidly, given everything that's going on. But pointedly, just to readdress your initial question, just because if the governor's order expires on July 7th, it doesn't mean that the very next morning, oh my God, all the emergency powers are over.
Great. So don't panic is the message I'm hearing from you, which is good. By the time we get to our next webinar, which is July 16th, we'll know where we stand, and if the order is lifted, we can have a specific discussion on what association should do at that time. And if it's extended, we'll be right where we are right now. So we'll look forward to having that discussion on the 16th. Guys, there has been some new guidance in the last couple of days regarding masks, I think in response to the spikes that we're seeing in positive tests. Jeff, I'm going to ask you, if you can, to summarize, very patriotic, by the way.
For July 4th, by the way, for all of our viewers out there.
That's really fun.
Happy Independence Day.
Thank you. Can you summarize for us what's going on in Palm Beach and Broward with respect to these new masks and new regulations? And then Michael,
I'll probably punt over to Michael a little bit on Broward, though I am prepared to talk about it.
Yeah, he'll take Palm Beach, because Broward and Dade are very much the same. So we'll let Jeff focus on Palm Beach.
Sure, that sounds good. And it's funny how different they are too, and we'll get into those subtle nuances. Now, I put on that mask in part to show that if we do a literal interpretation of Palm Beach County's order, I should be sitting in my office wearing that mask. Let's go through the language, and then we're going to drill into how what happens in our residential condominium and homeowner associations. But first and foremost, facial coverings must be worn by all persons, other than if you have an exemption, which we're not going to go into the exemptions today, but if you are ill and religious reasons, and there's a couple of others, while obtaining any good or service or otherwise visiting or working in any business or establishment, working in the establishment, visiting the establishment, when entering, when exiting, and otherwise moving within the establishment, you need to wear a face covering. This includes but not limited to restaurants, retail establishments, hotels, grocery stores, gyms, pharmacies, indoor recreational facilities, and even vehicles for hire. In addition, facial coverings must be worn by all persons in public places when social distancing, in accordance with CDC guidelines, is not possible. You need to wear them facial coverings in buses and when visiting governmental buildings. The question then arose whether or not, how this mask requirement interplays with life inside a residential condominium, life inside the homeowner association clubhouse. And it wasn't entirely clear because on the one hand, our associations are still Chapter 617 not-for-profit businesses. But that wasn't the type of business Section 4A of Order 2020-012 from Palm Beach County was referring to when it said facial coverings must be worn by all persons other than those exempted while obtaining any good or service when visiting a business or establishment. We were in touch with the Palm Beach County attorney, and the attorney then forwarded our inquiry off to another department head, John Van Arm at Palm Beach County, who commented back to me directly, residents and other person accessing common areas are subject to the mandate to wear facial coverings pursuant to Section 4B only when social distancing is not possible. So in the residential condominium and in the HOA clubhouse, there isn't a 24/7, if you will, mask requirement unless, and we're going to get into this in more detail later, but unless that association adopts a requirement to wear the facial masks 24/7. So if you're alone in the elevator, technically speaking, under just the county's order, you would not need to wear the mask. But if somebody else comes into the elevator, then in fact you probably would because you couldn't maintain the social distancing. So when you can maintain social distancing, not required. When you cannot maintain social distancing, it is absolutely required. When in any business establishment, be it a grocery store or my office even, sitting here on this webinar, and I've got the door closed so my mask is off. But if I walk outside my office door, I need to be wearing that mask. Technically speaking, strict reading of this order says even sitting here with nobody near me, I need to be wearing the mask.
So put it on.
Your mom would be proud.
And it matches my tie and the flag behind me.
That's funny. Michael, your comments on this whole thing and maybe Miami-Dade and Broward?
Sure. Well, I think
And
if you
where's
were
your
here a
mask,
couple
Bill?
of weeks ago, you guys know how I personally feel about wearing masks. It's been an unfortunate situation with the fighting people are having over them. But with regard to what we're talking about specifically, Broward County and Miami-Dade County reportedly worked in conjunction in order to establish the mask requirements. And I have not, the mayor of Miami-Dade County, he issued a report yesterday that said he'd be signing the order last night. I have not seen the order, but he did say that he had spoken with Broward County officials, including the county administrator Bertha Henry, who did issue an order, which I'll get to, and they agreed that a, quote, blanket facial covering order is needed at this time. So I have not seen the Miami-Dade County's order, but I am going to anticipate, although not 100% affirmative because they had talked about working together and then had different language, that they're pretty much the same. And the Broward County order, which is entered in and it takes effect tonight, is Broward County Emergency Order 20-20. And it also references the word establishment to include all persons in any establishment, business, or amenity. So I believe that would cover what we're discussing here, and what you listeners are caring about is your community association, a common area, common element areas. And it says that the following persons are required to wear facial coverings regardless of whether social distancing can be maintained. And let me repeat that. This is not an either or, this is an and. Social distancing should be maintained whenever possible, but even if it is being maintained, the county's orders are that masks should be also worn. And what's relevant to us is under section B, number 5, all persons while in any common area of a multifamily housing development or residential facility, including without limitation, the reception area, hallways, and elevators. So again, and they say without limitation, I'm not sure why they specifically named those 3, but obviously I will believe that is interpreted that it's any common area that's inside the facility. And so I think that, and Miami-Dade's order presumably will mirror that. I also want to remind everyone listening that you also need to know what municipality that you live in and whether they have issued orders, because while I have not seen a lot of orders from municipalities in other areas, these areas mandating masks have come up in, I believe, about a dozen municipalities in Miami-Dade, and at least 2 that I'm aware of in Broward. I believe Hallandale and Hollywood have both issued orders, and I've seen the Hollywood, I have not seen the Hallandale Beach. But then there's no less than 8 to 10 or maybe even 12 municipalities, I believe, in Miami-Dade that may have their own mask orders, which may be more restrictive. It can be. And certainly not, if they're any less restrictive, then the county order would apply.
You know, guys, it's very interesting. It is different everywhere, and I think the reality is, and kind of the position that Castle's taken is, we're advocating for common sense, right? Wear masks. That's the bottom line, and whether you can enforce regulations and you have some tools, but the reality is we're going to probably see this rolled out across the state if we continue in the same trend. So, again, we're advocating for wearing a mask, which is just kind of a common sense approach. Jeff, some would think that the new regulations maybe take pressure off boards to adopt rules with respect to masks. We asked the question last week, how many of your associations are utilizing masks in common areas? We had about 35% saying yes, 65% saying no. So it wasn't a well-adopted rule. Now that the counties are requiring it, what's your thought on whether associations should have their own rules?
Well, it's an interesting pickle that government has put our association boards in, because on the one hand, they have to ensure compliance. The association itself can be fined if someone's walking around not wearing the mask, and should be. And in fact, some of our clients are already receiving those types of notifications.
Wow.
But what is the association's, what are the tools of the association to enforce that compliance? A association board could not say, we're going to fine you or we're going to suspend your use right because you didn't follow the governmental order. That it doesn't work that way. The association would first need to adopt its own rule. So for those associations that really want to have the enforcement power over the owners, over the folks that are living and visiting, occupying the condominium and homeowner associations, you'll need to adopt your own rules and regulations to mirror what the county has. Now you have real enforcement power over somebody if they refuse to wear the face mask, again, subject to medical necessity, religious accommodation, and the other exceptions that are in the that the government provides for as well. But that is the only mechanism. So again, the association board can't just decide it's going to suspend your right to use the pool per se, in following the statutory regime suspension of use rights, because in a courtroom setting, which is what we lawyers always have to prepare for, right? We have to think of the worst situation and prepare you so that doesn't happen. So in a worst case scenario, a resident is upset because you suspended their use rights, but you haven't adopted any rules or regulations governing the reason why you suspended the use rights in the first place, which takes us back to 48-hour notice. And then the board can adopt reasonable rules and regulations, not with what someone can do in the unit. That's a different type of notice. It takes a 14-day. We're referring to what an owner is doing in the common areas and common elements, which is a 48-hour board meeting notice, and then publication of the adopted rule to all of the members. Then that board is in a good position to say, hey, you need to be wearing the mask or you could be fined $100.
Right. Well, we're going to talk about some enforcement things later, but great guidance, I guess. You know, if you advocate the common sense rule being to wear masks, you now have a little bit of leverage with respect to the county orders. If you really want to deal with this issue in your community, you need a rule, basically, is what I think you're.
Right, Craig. Otherwise, all you can do if someone isn't following, right, if they're not following governmental requirements and they're jeopardizing the association's position, you can call the police, you can call the CDC, you can call the health department and try to get some enforcement that way. But if you really want to use the association tools that Michael was actually instrumental in getting the Florida legislature to adopt in the first place, then they're going to have to adopt local rules.
Fantastic. Okay, thanks, guys. Before we move on to the kind of check-in on where we are with respect to amenities, we did have a question from a participant regarding the lifting of the emergency orders. And the question was, if they lift the order, does that mean I have to fully open my pool? And I think the answer, and correct me if I'm wrong, is no, that's not what it means. It doesn't mean you have to specifically open your pool right away.
That is correct. You are correct, Craig. If for some reason the governor does not extend the state of emergency, we then, as I mentioned earlier, we still need to ascertain the ongoing enforcement of the county or municipal orders. And then, and Jeff alluded to this earlier, and we'll get more into it. Also, the board's authority under your governing documents to adopt rules and regulations which address the health, safety, welfare of the community. So, with having the emergency or the state of emergency in place and having these county orders, it obviously makes it far simpler for the boards to be able to support the reasonableness of these rules. But I'm going to pray the unlikely event these orders get lifted, I believe you'll want to follow up with your council and make sure you're following what you need to be doing. It's what we talked about in previous webinars. It's the risk assessment and how the board would act. But no, it would not be an automatic, we need to open the pool.
Okay, thanks, guys. I want to just, for our webinar participants, I want to go to a couple of check-ins now, maybe compared to results a couple of weeks ago. We're not planning, with respect to amenities, I'm not planning to revisit all the status of all the regulations relative to the opening of the amenities. If you weren't on one of our last two webinars, we did talk about those specifically. You can find them on our website under the COVID banner /webinars at Castle, and you can go search those out. But I do want to check in on how everyone is doing. So I have two sets of questions for our participants. First, for those who live in an HOA, so this is for those who live in an HOA, we want to know if you opened your, I can't see the question. If we opened your pool, gym, and clubhouse, excuse me. So if you're in an HOA, have you opened your pool, gym, and clubhouse? Last week when we did this, which just while people are filling that in, approximately half of the HOAs had opened their pool, 14% had opened their gyms, and less than 10% had opened their clubhouses. So we'll see what our current participants are doing. We have about 275 participants. There were a couple of questions with respect to how many were online today with us. Once we get through HOAs, we're going to ask the same questions for condos and co-ops. But before we get to the condos and co-ops, Marinez, can you show us where we are with respect to HOAs and their pools, clubhouses, and gym? So guys, you can see these results, I think, correct?
Yes.
Yeah, so we have, if you open your pool in an HOA, 43%, so a little less, interestingly, than the last survey we did. And we're going to talk about, what impact this new spike has had. For those in HOAs, no, approximately 28% had not have their pools open. If you lived in an HOA, have you opened your gym? Yes, 17%, so up slightly from what we saw a couple of weeks ago. And I think that was originally because we were starting to get some positive momentum when we were reopening. So people opened up, and then again, of course, we've had the last couple of weeks. And then finally, have you opened your clubhouse? 4% of HOAs have their clubhouse open, about the same as last time. So not a lot of movement on the clubhouses. Marinez, can you go ahead and post question number 3, which is now for co-ops and condos? Where are you with respect to, again, pools, gyms, and clubhouses? So we will we'll wait for participants to weigh in there. And then, of course, we'll go on to our 55 and better communities. The results are coming in. It looks like, interestingly, if for pools in condos and co-ops, I will remind you that the last time we did this poll, about 2/3, 65% had opened their pools. I'm looking at the results coming in now. It looks like that's increased to about 75%. So 3/4 of the condos in our survey have opened up their pools, well up from the last time. With respect to gyms, 34% now. Last time, 33%. So not a whole bunch of new gyms opening. Very disappointing because I spent a lot of time in the gym. Not. But that's about the same as last time. And then common areas, 22% of people had open common areas in their condos. That's up significantly, more than double what we saw 2 weeks ago. So
I see 18%.
Sorry?
18% open common room.
What did I say? Oh yeah, it was 10% last time. So
Oh, that is a big jump.
it's a big jump.
Speaking of big jumps, Craig, I just got this news flash. It just came through from the Palm Beach Post. Florida cases grew 10,109 cases to a total of 160,006 cases. Total deaths 3,718, sadly. And Florida now has the undistinguished record to have beaten California for the most COVID in a day.
Well, let's talk about that in a second. Marinez, will you post the same questions for the 55 and over communities? And guys, I think what we're seeing in these results is exactly what we would have expected, 2 weeks ago, when again we were all kind of getting excited that we were on the other side of the curve, and we're heading for back to normal. And with this latest spike over the last kind of 8 days, 10 days, I don't know that we're not in a new normal, which is going to be wear masks everywhere.
Oh, I hope not.
Wardrobe, if you will.
Craig, while they're doing the poll, I'm no expert on this. I read what other people are reading, but you look at certain areas, you look at Europe, for example, who'd had a far different way of approaching, where they locked down for a certain period of time. They had, we had 44,000 new cases in the US. Europe had about 4,000 new cases. So there's a huge difference. Then you look at some states in the US, I think like Massachusetts or North Carolina or New Jersey, New York, where they were getting bombarded and bashed, and they really restricted and it worked. And so I think it's just, I know everybody's antsy. Listen, I feel the same way, but if people would just not fight over or politicize the idea of wearing masks, of social distancing, of just being smart, maybe we'll get through this all a lot faster, and this doesn't have to be the new normal.
Yeah, I think that's a great point. Let's just check in on our 55 and better communities. Few more pools open. This time, 49% of people responding had opened their pools. We were at 44 last time, so again, a few more. We are at 10% for gyms, about the same as last time, and 4% for clubhouses. So about the same in over 55 and better communities. Maybe we would expect to see that a little more conservative, probably given the high rate of incidence early in this whole process. So guys, from a participant standpoint, that kind of is where we are with respect to amenities. I would say this, with the explosion of new cases, we are seeing an uptick in the number of positive tests that are affecting our teams or vendors supporting our communities, and again, residents. So we're back to reliving the protocol of communication with the community when we see a positive test, shutting down amenities again. We've adopted back to work guidelines for our team. We're doing our own tracing, who they have been in contact with. Well, the good news is, clubhouses and management offices to a large extent are still closed. So by appointment only. So that's been good news. We're limiting kind of the contact with the team. But, we've adopted these rules. If you're test positive, you're exposed, this is what you have to do. You're off. You need positive tests, you're quarantining, all those types of things. I did want to ask one more question. I think Jeff or Michael, one of you touched on it earlier. Given what's going on in the world, are associations reclosing their pools? So Marinez, if you could post poll question number 5, have you reclosed your pool in the last 10 days or since our last survey? And then we'll come back and look at that. Not very many. A few, though, I think we're seeing a few close their pools. And with, I know one of our associations specifically A resident was tested positive. They had been at the pool, so they shut the whole thing down again. So small number, 4% are reclosing their pool. It'll be interesting to look 2 weeks from now when we poll again in terms of what the trend is for closing the pool. Okay, guys, any comments on those results before I move on to non-essential visitors? No additional?
No.
Okay.
No, that
I'm
doesn't
surprised.
surprise me.
No, I think you're
I'm
right.
surprised
I mean-
more haven't
Yeah.
reclosed their pool at this time. I'm a little surprised that it's only 4% that have reclosed. I thought it would have been a little higher given what's going on, but we'll see how it plays out the next couple of weeks.
I agree. Let's go to non-essential visitors, guys, and just check in again. Under the emergency powers of the board discussed earlier, the board was able to adopt rules limiting access to the community. We've talked about that. In most cases, associations adopted rules to limit non-essential visitors, family, friends, realtors, contractors, etc. So from our participants, I'd like to ask what you are doing in your community with respect to non-essential visitors. So Marinez, poll question number 8, if you don't mind posting, to what extent are you allowing, for HOAs, if you live in an HOA, to what extent are you allowing guests and non-essential visitors in your community? So as we get those results, I will remind you when we asked this last time, about 65 to 70% of the community's HOAs were allowing contractors, realtors, family, and other non-essential guests. Interestingly, they were more apt to allow contractors into the community than families, so that's an interesting dynamic. But let's look at, Marinez, if we could close that poll and post those results. So if you're living in an HOA, to what extent are you allowing contractors, realtors, family, and other non-essential guests? Contractors way up, 93% versus 69% last time. Realtors, again, way up over 85. Family still less than contractors and realtors. And then non-essential guests, about 60%. So what we are seeing, again, I think is the same theme here, guys. A relaxing of the rules, from just 2 short weeks ago. And that was before all the news that we've heard.
Yeah.
Mike, I'm gonna ask you, what advice you're giving your clients with respect to these rules. But before that, Marinez, can you post poll question number 9 so we can see what's going on in condos and co-ops?
Yeah, and this one is the one I'd like to see. I'm curious to see how they're doing, because the HOAs, what we don't know obviously are these attached homes or these single family homes. I think in a single family home environment, you're far more likely you're not going to have those types of restrictions. As far as what advice, if client, well, first of all, when it comes to relaxing the rules, and I encourage all of you, if you're considering relaxing rules, this presumes you've properly adopted rules, contact your legal counsel and get with your management team and discuss what it is that you'd like to do. And then my advice to them is to communicate with counsel in how you want to go about it and what your objectives are. I had a few clients who have reached out and said, here's what we're looking to do. And some of those things, I think it's absolutely, if you're going to allow, you're going to relax these rules and allow non-essentials or contractors or realtors, limiting the number of people who are able to be in at one time, requiring them to be masked, temperature checks, if you do temperature checks. I mean, those things, all of those things I think are reasonable when you're talking non-essential. Even with essential, I think today it's certainly okay to say for anyone coming in to be masked.
Guys, will you share those results, Marinez? Because they are interesting. Again, much higher than much higher than what we saw 2 weeks ago, even. So, consistent theme, right? Contractors. Most associations are now allowing contractors, realtors, family, and to a lesser extent other non-essential guests. But certainly the big 3: contractors, realtors, and family.
Yeah.
Way up.
I hope, and I would surmise that they're allowing them in with certain restrictions, uniform restrictions being in place. It's not just business as usual.
Yeah, I'm going to guess that's the case as well.
But that surprises me.
Yeah, that's a really high. So for our participants, that tells you what your neighbors are doing, so you have some idea, maybe some ammunition if you're not doing it. maybe you're a bigger target if you're on the other side of some of those stats, but at the same time, that's the data that we have. Jeff, I want to jump into rule enforcement. You talked about it earlier. We get a number of questions about enforcing rules and what tools we have. Whether they be wearing masks, use restrictions on the pools and other amenities, access to non-essential visitors. We've talked about these tools, but what I wanted you to do, Jeff, if you can, for our listeners, can you confirm for us the process that the board should follow in order that they have a proper rule that they can enforce?
Sure. And we're talking about a rule that pertains to common areas and common elements, not what someone does inside their unit. No loud music from your unit past 8 o'clock at night is a different process than wear a mask when in the common areas, wear a mask really when outside of your unit, you need to wear a mask. Right. Let's think of it as a 24/7 mask requirement in the condominium. Now, this is far more important. It's actually important for Broward and Miami too, because even though the governmental order is stricter, I suppose you might say, than in Palm Beach County, where it's only if you can't social distance inside the building and in the common areas, common elements. If the board itself wants to be in a position to use its enforcement powers, it needs to post a 48-hour board meeting notice. It's consideration of a rule to be adopted governing face masks. It needs to then have a discussion at the board meeting, proper motion, a second, opportunity for membership input. They'll be prepared. There will be the vocal minority there. I understand there's a Palm Beach County case right now. Someone is suing, claiming wearing masks is unconstitutional. So for what that's worth, I think there's 4 people involved in that in the entire county. So that tells you it's a very small point of view, I think. But in any event, once the rule is passed by the board, so assuming the motion passes, then, member comment was solicited, et cetera, minutes are prepared, and then the community is notified about that rule. As soon as the community is notified that the board adopted the rule, that rule is now in play. HOAs, remember, to be on the right side of the law, you also want to record that rule. Now you can fine the board at a properly noticed board meeting. Once again, can begin to use the enforcement powers if someone isn't following the rules. So the board considers the matter. It then makes a decision that we're going to fine somebody, or maybe we're going to revoke their access card, use right card to the swimming pool. That person has to be provided notice that the fining committee, whatever word you want to use right committee, will meet on a particular date, and that notice cannot be for sooner than 14 days from the time it's dropped in the mail. It's not if the person wants to appear in front of the fining committee. It's mandatory that that committee meets, even if the person isn't interested in going to the committee meeting itself. Committee meeting must meet. And if they say anything other than yes, in terms of what the board had decided, it's a no. That committee has no power whatsoever to modify anything that the board decided should be the suspension or the fine. And there are limits as well. Mike, why don't you jump in here a little bit too, because you were so instrumental in getting this procedure put together out of Tallahassee.
You were doing such a fine job. Well, listen, basically, just to add a couple of things to that, I want to remind everyone, as Jeff pointed out, you have to properly adopt the rule, and you have the authority to adopt rules. The rule can't conflict either expressly or by implication with your documents, and it has to be reasonable. Presuming you have the authority, and I believe most communities will certainly have the authority to adopt rules, like Jeff mentioned, for common area, common element, you're almost assuredly going to meet those 3 points. So you properly adopt the rule. What the board also should do is establish your fining policy or your suspension policy at a properly noticed board meeting. Because the role of the board, as per the statutes, is to establish the violation and levy the fine or the suspension. That's the board's role. So the board is the one who's going to say, we properly adopted this mask rule. You weren't wearing the mask. Therefore, per the fining policy, you're being fined $100. And this first time, if you do it again, you'll be fined $100, and you'll have your use rights to these amenities suspended for 30 days, for example. So if the board's established all of that, and that's been properly noticed and processed to the membership, The role, when you end up before that committee, the role of the committee is very specific. The committee's role is simply to hear the presentation from the association, the board, the management. And the example that I've constantly given, I'll give it here again, is the committee is the judge and jury. They sit and they sit and listen, and the association, presents the case. They're the plaintiff, the prosecution, if you will. The violator, if they choose to show, is the defendant, and the association presents its case, provides its proof, should have good sufficient documentation, witness testimony, etc. If the individual shows up, they can defend themselves however they deem it appropriate. The committee then deliberates essentially and makes a decision. Yes, we agree with the board, and we're confirming what the board has said the fine and/or suspension will be, or no, we don't agree and we are rejecting it. If they agree, the fine or suspension is imposed. The board levies, it doesn't get imposed until the committee confirms. If they don't agree, then it's rejected and it doesn't happen. Okay, so that's the role of the committee. The committee doesn't have discretion to say, yes, we believe there's a violation, but we think $100 for that's too much. We're going to only approve 50. That's not their role. Their role is either confirm or reject. So what you want, so it's a very important policy to establish. And again, please get with your counsel. Get with counsel, get a written opinion on the proper process to follow as far as how you can establish your violations and your notices to the individual about the violations and about the fines or suspensions, and then how you and what you need. By the way, fining committees are not board members on either HOA, condo, or co-op. The members of the fining committee need to be owners who are not directors, officers, employees, or certain levels of relatives of them, spouses, brothers, sisters, I believe, are a couple of them. So you have to also establish an independent committee to approve, to confirm or reject those fines or suspensions.
So guys, so really no shortcuts here, right? Like this is the process before the pandemic. You have these tools. You have to have a committee. You have to have a board meeting. You have to have a properly noticed board meeting, a properly noticed committee meeting before you can really do anything. So there is process and no shortcuts, I think is what you
No, and the reason for all of this, and you're absolutely, there is no shortcuts. And the reason for this is, and again, enforcement is a big challenge. And that's one of the things when you're adopting these rules, you have to decide, okay, we want these rules in place, but you also need to know you can enforce them, and you can't enforce them selectively or you're going to lose the ability to enforce them. Right. So it's an issue of enforcement. And if you do properly adopt the rule, properly fine and or properly suspend, or let's use with fines, and the individual refuses to pay. Well, in order for your attorney to be able to assist you in collecting on those fines, you need to have the documentation that we talked about, the board meeting, the minutes of the board meeting, the proof that you followed the violation properly. And unfortunately, sometimes you might have to prove up the violation existed again in order to collect the fine. But that's, let's use a concrete example. Jeff mentioned earlier, we have some clients who've been threatened with fines if they're not complying with the mask order. Now, so if you have an individual walking around the lobby not wearing a mask, my understanding, at least in a couple of cities that that clients have talked to me about, is the code inspector recognizes that the association's doing their best, but the code inspector is not going to fine that individual. They're going to fine the association. So if the association wants the ability to be able to hold the violators accountable, fining is one way, as far as that goes. And so that's why it's important to follow that process to be able to try to collect that money later.
And I do want to tag into that there are exemptions to the wearing of face coverings. Children under 2, some professions, it's not warranted and you cannot do it. So that could be another reason why. Public safety, fire, or other life safety personnel that have protective equipment and other requirements. Individuals while actively engaged in exercise, but only when maintaining social distancing. Person receiving goods or services from a business or establishment for the shortest practical period of time during which the receipt of those goods or services precludes the wearing of it. In other words, there was some kind of reason why it could not be worn. People with a medical condition, people who have conflicts with their religious beliefs, and face coverings can also be removed temporarily when assisting the hearing impaired or to assist people when reading lips.
Right. Okay, so I think fair enough, guys. So I think if I could just summarize, because a lot of data there, in order to enforce, you have to have a rule properly adopted. You cannot enforce unless you've got the appropriate kind of grievance committee platform in place. And then if the association has some exposure here to the extent they don't have a rule with respect to, let's say, masks, they can't enforce, someone's walking through the community, should be wearing a mask, perhaps they even get fined by the county. Is that a fair summary?
Right. For any association that's in harm's way because they have a resident that is not complying, they need to put a record together. They need to keep accurate notes, if you will, video, etc., and then immediately begin to involve law enforcement, your code enforcement officers, to the extent only, however, that they won't throw the association under the bus. But if they're willing to come in because Mrs. Smith, Mr. Jones won't comply, and they're willing to knock on the door and maybe help with that situation, maybe government can be of service. Time will tell on that.
Right. Thus far, that's not been the experience, though, that's been reported to us, that it's the association who's going to be hit. And so, to that point, also, there's language in governing documents, and this is something to review with your counsel, that says if an individual causes monetary damage to the association, that they'll be held responsible. This may be one of those situations that if you can, again, properly document the violator or violators that you were cited for, then that may be a situation where you get with your counsel and try to recoup those funds. And I mean, really, all we're talking about here is just wear a mask. If that's the requirement, just wear a mask. Be a little bit, inconvenienced, if you will, but it's a selfless act. And if you don't have a fine or grievance committee, obviously, if you don't have a fining committee, you cannot properly impose the fine. So if you're not able to get volunteers to create this committee, then you are not you can have these rules, but the idea in order to enforce the rules, what you're doing is you're sending demand letters. You're then reaching out to council and having council send a more firm demand letter, and ultimately possibly having to file actions for injunctive relief.
Right.
Court action.
Right. And there's one more thing I want to bring up before we run out of time. Dealing in Palm Beach County, Michael, you'll have to address, I don't know if you have this requirement in Broward or Miami-Dade, but anyone that has the mask requirement in Palm Beach County also has a signage requirement dealing with signs posted on the entryway into the establishment governing the need to wear a mask. And you can go to the Palm Beach County website, pbcgov.org, and you will find examples of all of those signs there. I know we posted it on our office door.
And I don't recall seeing that, although, like I said, the order just came out, but regardless, the sign should be posted. I think, and if you're not sure of the language, then use the Palm Beach County language as a guide. The same way we talked about when the pools reopened, and Palm Beach County's order had specific signage for the pool. Broward and Miami-Dade didn't, but we said Broward and Miami-Dade, use this. It's a good idea. And again, remember, talk with your insurance agents. Make sure you're following the requirements of your insurance policies, that you will be, if you have certain coverages, that you're best protected.
Yeah. Guys, I want to get to the issue of litigation and risk and things like that. And the one question I want to ask our audience, and it's poll question number 5, Marinez, before we get into a discussion, is have you contacted your attorney regarding your emergency response plan? I think, we know litigation is coming, guys. Jeff, I'm going to ask you, what can an association do now to put it in the best position to defend itself when the inevitable lawsuit comes?
Absolutely. Starting with read Palm Beach County order. If you're in Palm Beach County, 2020-012. If you're in Miami-Dade Broward, read the local order. It even has a section on compliance for Palm Beach County. And imagine if you don't comply with what I'm about to read to you, and you do have a COVID outbreak, and God forbid someone passes away, and you didn't follow this requirement. All business and establishments, as provided for in Section 4 of this order, which is everybody, shall ensure compliance with the provisions of this order, and shall establish a process for verification of compliance upon customer entry into the establishment. So can you imagine the situation where the association doesn't have any kind of process, where it doesn't post the required signage at the front door? They didn't say just those businesses subject to Section 4A or 4B, of their order. They said all of Section 4, which is any business. And associations are still a business. So that argument is still out there that the association should have posted that signage and needs to ensure verification of compliance upon customer entry. Something as simple as this. Michael, let's give an example. Put your head closer to the screen and we can take your temperature. I wish we had that technology, right? We don't. But if someone's coming in, I see no harm if the board passes a rule. If you have a fever above, I believe with this one, it's 100.4, because these have different degrees and things like that than the oral thermometers. But if you're above 100.4 and you don't have to touch the person in any way, it goes about an inch from the forehead, that can help ensure compliance as well. Face mask, you're not going to let people into the building without a face mask. Occasionally, somebody may have an error. Fine, you don't have to go jump off the deep end and find them. Give them a phone call, log it, send them a warning letter, keep a copy of it, show that
have an inventory of masks that you could give to them.
Sure, yeah. If they don't have one, give them one on the way in.
And just Craig, just so you know, the Broward County order does say this as far as responsibility. All persons are responsible for complying with the facial covering requirements of this emergency order. All establishments, which is the associations, are responsible for ensuring all employees and patrons of the establishment comply with the facial covering requirements of this emergency order. So that is basically saying the individuals are responsible as well as the establishment. And as we pointed out, at least in the very limited information I've received from a couple of these cities that have these mandates, that the code inspectors are holding the establishment, not the individual, even though the order says the persons are also responsible. Miami-Dade's order, I surmise, is very much the same as Broward's.
Guys, I want to post the results. Are a little troubling, actually, with respect to, the amount of risk I think an association has in, adopting rules, maybe outside normal protocol, having meetings, having a plan, documenting. We see that only 60% of the associations kind of represented here are actually have back reviewed their plan and their exposure with their attorney. So it's a great advertisement for you guys. Highly recommend, excuse me, from Cass's standpoint, that you get your plan blessed. It's not too late. You can ratify the decisions you made, I believe. If I have that right, guys, is that correct?
Yes. Yes. And again, we're talking business judgment. Board members, we're talking your reasonable business judgment. Relying on your experts, your legal counsel in this case, is one of those factors that supports you doing the right and wrong thing. I know people sometimes fret, hey, we don't want to spend money on the attorney. This is an area you do want to spend money on the attorney. Whomever your attorney is, we're happy to do these free programs and give general guidance. But we do encourage you to really get with your experts and get these things in play as this process is ongoing and evolving. Now we're talking about the issues with risk mitigation, with enforcement, and these are clear legal matters. So yes, you got to spend a few bucks on the attorney to get these things done right.
Consider it.
You want to show, because ultimately, if you get sued, you want that record. You want to know that you have an attorney. I mean, I know it might sound a little silly, but worst case scenario is you'll have a attorney bill to show that you reached out to the attorney and you complied with orders, and anything you can do to show compliance.
I think it's a great investment for those people who haven't done it, for sure. And we're advocating for every one of our clients. We've published plans. We have all these best practices. Every time we've had a discussion, we have the attorney involved, and it may seem like a check you have to write now, but it's a much better check now than when you're defending a lawsuit that you didn't process.
And it's typically, we're not talking a lot of money, and we're not talking a lot of time either, typically.
Yeah. Right. Okay, guys. Well, thank you. Before I go on, our next webinar is July 16th. We will know what's going on with respect to the emergency order. We'll be able to talk about that. We're also going to talk a little bit about that time, what associations can do to protect themselves before the next, necessity of an emergency order. I wanted to remind participants that we're looking for feedback. If you could post a Google review for both Kay Rembaum and Bender, and also for Castle, that'd be great. On the screen, you'll see how to do that. Guys,
you shifted our names, huh?
I liked it.
Great guidance as usual. Parting comments, Jeff?
None. Just thank you, everybody, for attending, and we're glad to be able to lend a hand and provide some guidance to the overall community association world.
Awesome.
Yeah, thank you everyone for attending. Hopefully everyone got some great info. Have a very safe and happy 4th of July weekend. Like many businesses, our offices are closed tomorrow, but everyone stay safe, be smart, be selfless, wear a mask.
I would say the same thing.
Well said.
Thank everyone for joining us this afternoon. We do really appreciate your participation. Guys, as always, a pleasure. Have a wonderful long weekend.
Same to you.
Everybody stay safe and wear masks. That's what I would conclude.
Thank you.
Thanks again, and thanks